Thank you for clicking this video. This is Batok with Ola. My name is Mujela Oluwa, and today I want to talk about customary tenancy in Nigeria. Customary tenancy bothers on or relates to land ownership, and possession of land, generally. Although it's been ousted by the Land Use Act of 1978, the Land Use Act. It is something that we need to discuss because it is still operating or operative in some quarters. And there are tenancies, customary tenancies that were in operation before the Land Use Act that are still in operation until today. So it's something that we should talk about and something that we should understand. Customary tenancy is basically the act of granting possession of one's land to a person who would then be called the customary tenant in exchange for tributes, So it's different from tenancy, ordinary tenancy, because ordinary tenancy deals with payment of rent. But in customary tenancy, the tenant just needs to pay tribute to the landlord, an agreed mode of payment, and the quantity of whatever the tribute is or is determined to be. So basically, there's someone who owns land, then he grants the occupation and use of that land to another person. And in return, that person recognizes the owner's title, recognizes the fact that they are not the owner, but they only have possessory rights, and then they pay tribute, in recognition of the title of the owner. So usually it takes place when someone maybe has land that they are not using, so they do not want to sell it, they do not want to put tenants on it, but they can give it to someone that needs it for a particular purpose that's agreeable to them, maybe for farming, even for settlement or for any other purpose. They could say maybe you need this land for cash crop farming, so every year you give me maybe some part of your produce, say maybe a keg of palm oil if it's for palm oil cultivation, or maybe you give me 10 tubers of yam. So they continue to pay this every year in recognition of the owner's title. So essentially, when they bring their tribute every year, what they are saying is that we recognize the fact that no matter how long we stay on the land and whatever purpose we use the land, of course, the purpose that we've agreed to use the land for, we recognize the fact that we are not the owner of the land. Your title is not extinguished by the passage of time or the progression of time. So you're still the owner, and so we recognize that. So we're bringing you this tribute, for giving us the land to use for free every year. So, or maybe every 6 months or every harvest time, as they may agree. So a king could give, portions of his land to maybe foreigners or even indigenous of the land in those days, They become his customary tenants, they pay him tribute. A family, could give out their own land to some other members of their family or people that are not even members of their family. So the land remains in the family, it remains the property of the king, but the possession moves to the customary tenant. And in recognition of that title of the owner, the customary tenant pays tributes every year or as agreed. So it's different from tenancies, from leases, in the sense that it's not for a fixed period. It can inure in perpetuity. Even the original owner could die and then they keep paying tributes to his successors, his own progeny, as the case may be. So that's one difference. And what is paid is not rent, it is tribute. We're recognizing your ownership. So usually this tribute is not necessarily commensurate to the value of the land because it is not a tenancy. And it could be the same thing for years. It could be over 10, 20 years, they could still be paying maybe 1 keg of palm oil every year. And they might even be making maybe 50 or 100 kegs of palm oil from their cultivation or usage of the land. So it is not necessarily a tribute that's commensurate to the value of the land or what they are deriving from the usage of the land. It is just something, a token to continually recognize that they only have possession and are customary tenants, but the ownership resides with the owner of the land, the grantor. with the owner of the land. So what are the terms? There's the grantor, the owner, and the grantee, the customary tenant. So grantor, grantee, and the relationship between them is customary tenancy. And the consideration for the value exchange is what is called tribute. Like I mentioned, the grantee does not morph into a grantor or the owner by the progression of time, no matter how long the tenancy endures for. But the owner cannot just chase them off the land. So sometimes it becomes even difficult to determine the customary tenancy so long as the grantee is of good behavior. So the most important factor to consider in the determination of customary tenancy is good behavior. In most cases, it's good behavior. And good behavior is not something that is so easily defined or interpreted, in the sense that you cannot just say maybe for a little misdemeanor or a little misbehavior on the part of the grantee, then you determine the tenancy. No. So sometimes it can be difficult even for the owner to retrieve their land from the customary tenant. And this provision under customary law is made so that people who enter into customary tenancy can have peace of mind and rest to use the property, because usually they use the property for a long period of time. If you're going to cash crop production, you're envisaging a long use. Sometimes the customary tenants even develop fixtures and fittings on the land. Maybe they build houses, farmsteads, they put machinery and whatever on the land. So the owner cannot just wake up and say, oh, you did not greet me today, or maybe your tribute failed at the time it was supposed to come. It's never failed before, but I'm not just going to pardon you. Or maybe I heard that you spoke about me in a manner, and then I determined the tenancy. So the considerations for what is bad behavior sufficient enough to determine the tenancy, they are very stringent, and several cases have gone to court and have been decided, along these lines. So I'd leave some cases in the description box. Please, if you'd like to read upon them, you should do. Just like in normal tenancies, if once there's a customary tenancy established, the landlord or the owner cannot just move into the land as he pleases, because the tenant now has exclusive possession. So he needs to go through the tenant if he needs to enter into the land for any purpose. So the exclusive possession is very exclusionary, even exclusive of the landlord or landowner. Now, when I've said that when a landowner dies, the customary tenancy does not determine, so long as there are successors who can continue to receive the tribute, and the customary tenant continues to recognize their title as the owner, now the new owners of the land. In Abdu, Lasisi and Tubi, the Oloto chieftaincy family had given their land to some people as customary tenants, and then they sold that land. So when they sold the land, the new overlord, the new owner, wanted to eject their customary tenants, and the court held that the new owner could not eject them, that the best he could do was to step into the shoes of the former overlords and become the landlord or landowner to whom they would now pay tributes. So just like the original owner could not just eject them at will, the new owner could not also eject them. So essentially in that case, the court decided that when transfer of title, goes from a grantor who has grantees on the land to a third-party purchaser, the overlordship also passes. When the third-party purchaser is purchasing the title, he does not purchase, the right to evict the customary tenants. Very interesting decision. So that means that once you create a customary tenancy, you limit even your own rights over your land or property to some extent, especially if the customary tenants can continually prove that they are of good behavior and they are paying their tribute and recognizing your title, as the owner, not that they are usurping the title or doing anything inconsistent with the terms of their tenancy, like maybe leasing out the property or selling the property outright. They do not have a right to do that. But when you sell to, you do not sell a right of eviction of customary tenants to your purchaser. So the purchaser, as held in that case, cannot come and chase your customary tenants away. At best, they just renew the customary tenancy you have with them, such that they now become the ones that are accepting tributes, and the one who has the title, whom the custom, which and the one who has the title, which the customary tenant, the grantee, now recognizes. While a very key factor to determine the existence of customary tenants would be the payment of tributes. Payment of tributes may not be applicable in all cases. For instance, in cases where there's been such a long relationship, a good relationship between the grantor and grantee, that the grantor asks the grantee to stop paying tributes, or maybe they've not paid tribute for so long and they've been of good behavior and the grantor has overlooked it. So payment of tribute could also stop. It might not be regular, but once the grantor is okay with it and there's a good relationship between the grantor and grantee, it will not be a deciding factor in determining the tenancy, the customary tenancy. Customary tenancy is under customary law, like I said, and it is more about relationship than it is about exchange of value. So it's a means by which people, created and maintained, good relations with total strangers, with neighbors, with friends, and with acquaintances, even relatives, as the case may be in those days. It is still in operation to an extent today, but what we have more of is outright sale tenancies, leases. What are the means of determining customary tenancy? That is the means of bringing customary tenancies to an end. The first is denial of the title of the owner. So once you begin to drag title with the grantor as a grantee, the tenancy is going to be determined, because no matter how long you stay on the land, you're still a tenant, a grantee, not a grantor. So denying the title is one of the easiest means of putting an end to customary tenancy, claiming to be the owner. Now, another means is using the land in a manner that is inconsistent, and this would be serious cases. Not that maybe you said you plant cassava and then you're now planting yam. We're talking about maybe you said you wanted to use it for planting crops and then you sold it or you lease it out, doing things that are inconsistent with the terms of your tenancy. You do not have a right to lease it out, you are not the owner. You do not have a right to sell it, you are not the owner. When you begin to do these things, you easily lose your tenancy, and the tenancy can be rightfully determined. So if you were to sell or to lease out the property, you can easily lose, or you easily lose the tenancy. It comes to an end because you don't have a right to do any of those things. So you're not the owner. The title does not vest in you. So you cannot sell, you cannot lease out. So when you do things that are inconsistent with the terms of the tenancy, it comes to an end. Abandonment is another reason. If you abandon the land for so long, then the owner can take it over, and it can be safely assumed that the tenancy is determined and you are no longer interested. Because abandonment would also mean that you've not been bringing your tributes, you have not been using the land, the owner has not been able to find you in usage or occupation of the land, so they can just take over their land and move on. Express surrender or release is another form of determination of the customary tenancy. So you could just release the land back to the owner, surrender it, tell the owner you're no longer interested, you are done, you are no longer interested in the tenancy. Then another means of determining the tenancy would be when you have completed the purpose for which you established or went into the tenancy. Maybe you said, okay, I want to produce cash crops in industrial quantity for 10 years. Maybe you have a contract for supply of those crops, and when those 10 years come to an end, you're folding up the business. So the purpose has been fulfilled, completed. The tenancy can safely come to an end. Forfeiture is a means of determining the tenancy, and that would mean that you have denied the title, like I said, of the owner. So you forfeit your rights as a customary tenant, and the tenancy would come to an end. Then another means would be if you have not been of good behavior, and I've talked about how serious it needs to be, not just any trivial misbehavior on your part. So as a grantee, bad behavior, unacceptable conduct is also a means of determining the tenancy. Non-payment of tribute can also be a means of determining the tenancy. And it's not necessarily the fact that maybe you did not pay for a year or two or three, but the court, if it goes to court, or whoever is deciding it will look at the circumstances. Was it willful? Was it deliberate? Was it an affront to the ownership or the rights of the owner? Why? What are the circumstances surrounding your non-payment of tribute? That would determine if it is sufficient, to put an end to the tenancy or not. Alienation or attempted alienation could also determine the tenancy. If, for instance, you try to sell the land or transfer your interest in the land to a total stranger, and of course without the consent of the landowner or your landlord, that could determine the tenancy. So essentially, customary tenancy is a means of transferring property to someone, the possessory rights in one's property to another person. It usually affects family land or basically land that's communally owned, and that's in exchange for tributes and the recognition of the title of the owner or the transferor. That's the grantor, and the tenant is called a grantee, and they have to continue to pay tributes and recognize the title of the owner. They cannot sell, they cannot transfer it to another person, and they must maintain good behavior for the tenancy to continue. And I said the tenancy can continue for as long as possible. And the important thing is to maintain a cordial, a wonderful relationship between the grantor and the grantee. If the grantee does anything to destroy or to tamper with this relationship, it could lead to the end of the tenancy. But if they are of good behavior, they have even stronger rights that can override the rights of the owner, as I've explained in some circumstances. So that's all I want to talk to you about in this video. I will see you in my very next video. Don't forget to subscribe to those.